So I'm going to turn to recommendation 13. Lawrence, if we could have page 38 of the report. So recommendation 13, I recommend that interest be payable on awards for past financial losses and past provision of care from the date of infection to the date of the award, in accordance with the practice in personal injury damages claims, alternatively that such awards are uplifted for inflation during that period. And if we just go to page 121 of your report, I'm not going to read aloud paragraphs 9.123 through to 9.127, but I think it's fair to say you set out there the position in relation to claims. I think that reflects the position in England, Wales, possibly Northern Ireland rather than Scotland.
Almost certainly.
You set out the arguments, as it were, for and against in either an uplift for inflation or the payment of interest in 9.124 and 9.125. And then over the page at 9.126, you say, nevertheless, I consider that the effect of inflation must be recognised either by an award of interest or by an uplift by reference to an inflation index. This does not apply to lump sum awards awarded for non-financial losses apart from past value of care, where the award is made at the value applicable at the date of the award. And so you recommend that either, and we see in 9.127, this is effectively reflected in the terms of recommendation 13, interest or an uplift for inflation. If the compensation scheme is put into effect and adopts this recommendation, in terms of the interest rate, you haven't, I think, made a specific recommendation as to what the interest rate should be, other than referring to what the position is in personal injury claims in England, Wales and Northern Ireland.
Well, there's in personal injury claims, there is a statutory rate which is applied by reference to a formula which is then applied to, and I think that's what I had in mind. But obviously, greater minds than mine might have arguments to make about what the appropriate interest rate should be. But I think the principle is that it needs to be either interest or inflation, one of the two.
So that's a decision that would have to be taken by those setting up the scheme. Yeah. But the starting point, the principle is that it should be built in.
Yeah.
The starting point would be to look at what the interest rates are in damages claims, looking at both England, Wales, Northern Ireland and Scotland, yeah, to see whether there is common ground or to the extent of any differences, and then identify the right rate.
I think any differences should be ironed out. The same interest rate should apply, yes, whichever country you live in.
So if we then turn to recommendation 14, so if we go back to page 38, thank you, Lawrence. So this is interim payments. Now, we looked at that obviously yesterday in terms of some of the issues of principle, the reason why you made the recommendation for an interim payment, and the degree of, in a sense, urgency that underpins it. Can I just ask you now a little about why you expressed the recommendation in the way that you did in terms of its scope? So if we go to page 122, you've set out, again, I'm not going to read through the pages, but they're there for those who want to read the report or reread the report at 9.128 through to 9.137. The recommendation is the making of interim payments to infected individuals, eligible infected individuals who are alive. Is that correct?
Yes.
Why does your report not recommend interim payments to the estates of those deceased? At least those who are already known to the schemes, and therefore there's no eligibility issues.
I recognise that making an interim payment in advance of the scheme being set up was undoubtedly an exceptional measure and justifiable by reason of the urgent need of a particular group of people, and to my mind those were the eligible living infected claimants, and of course again it could be extended, and that was the need, whereas the calculations required for those who were no longer with us Firstly, I've not extended the suggestion to the living affected. And again, in part, that is due to, I mean, I'm not for a moment saying that there aren't people in all categories who have, as it were, an urgent need for money. But part of it is due to how simple or otherwise it is to determine what would be an appropriate amount to award, actually. The thing about an interim payment is that you don't want to pay more than, I mean, in the extreme case, you don't want to pay more than it turns out a person is entitled to, because that leads to obvious complications. In the court setting, an interim payment will, generally speaking, be no more than the very minimum that someone might be expected to get in a particular circumstance, and so there is already a heavy discount involved in that. And it does seem to me that both for the living affected and the deceased infected, firstly, without wishing to, understanding the dangers of overgeneralisation, the needs are not so urgent. I mean, the urgency of the need I identified for the eligible living infected is that many of them are worried about dying before they have any idea whether they're going to get compensation or not, and not being able to settle their affairs. That is not a need shared in quite the same way by the estate of someone who has already died or by an affected person. So I start from the point of view that this is utterly exceptional with the idea that you have an interim payment before the scheme is set up and the rules are fully explored and known. But happily, there is a means by which such payments can be made already, because there are support schemes, there's an administration, there is an identity available as to who's eligible, and therefore it's partly the ease of identification, but also partly because the very striking need of this very narrowly defined, quite narrowly defined group of people.
Can I just explore one or two additional points with you arising out of that? By only making interim payments to those infected who are still alive, that may continue to leave those who receive no support at all. An example might be parents whose child died, or children in some cases died, waiting longer for any form of compensation. That may, in fact, they may never live to see that, bearing in mind that they may be of an older generation. Any reflections on that?
Well, as in so many areas in this, there are lines, it seems to me, one has to draw. The claim that would be made by a parent would be of necessity a less certain claim than one for an eligible infected living person. And therefore the assessment of that, it would be very difficult, I think, to identify a common figure which could be awarded to all cases. And this has to be a common figure because by definition, the scheme is not in existence. We haven't gone through the medical panel issues, the legal panel issues. We haven't got assessors. So we're dealing with something that needs to be a very generalised payment in terms of what it is. And I obviously made a suggestion about the amount, but whatever the amount is, and the more people you include in the category, the lower the general shared amount is going to be, but by definition, I think, logically.
Might it be said, the longer it takes for the government to respond to your report, and of course at the moment there is no response, and assuming that there is ultimately a response which says there will be some kind of scheme, the longer it takes to set up a scheme, the stronger a case might be for a wider range of interim payments, precisely so that the kind of categories of individuals who I've given an example of don't die still waiting for
forgive me,
something.
But I think there's you could make a case of varying degrees of compulsion for virtually everyone who could make a claim. I mean, there's no doubt that everybody who aspires to receiving compensation will want the matter settled as soon as possible. That's part of the underlying reason for many of the recommendations I've made. What I'm seeking to address here is a very particular need. I would agree that the longer it takes for there to be a response, the urgency in relation to the group I've identified gets greater. There's no doubt by definition. And I'm not sure I could say that applies. I mean, there is an existing need to settle things that everyone else shares, but I'm not persuaded myself that falls into that more people then fall into this category. And as I said, the wider you draw the category, the less easy it will be for the government, I suspect, to identify what they would consider to be the appropriate figure to pay. So actually it might be slightly self-defeating in the sense that they talk about complexity, and I acknowledge there is complexity in everything in this report, as your questions demonstrate. The idea of this was that it would be something that, maybe I'm being naive, it should be quite simple to make a decision about. Can I put it that way?
The figure of £100,000 for the interim payment for those who you've recommended should receive it, as I understand it, reflects an assessment of that's a proportion of what people are likely to get, and so there shouldn't be an issue. If you pay that, you're not likely to have to be in the situation of having overpaid them.
Yes, and I will be the first to admit that my attempt to produce a figure was not based on a hugely sophisticated calculation, but I did take into account what looked like a potential and arguable range of awards for the impact award, and really it's around that and perhaps the autonomy and so on that we're talking about. Excuse me, here. And but the idea, my idea, was that it would be a significant, an award no one could say was not a significant sum of money, but was likely to be one which most, if not all, infected applicants would reasonably expect to get either that or more, or something close to that. And I would hope that there might be a group of people for whom that would be sufficient. I mean, clearly it wouldn't be sufficient for many, but it would be for them it would be a start, and it would put money in their hands, which would enable them to make choices, to remedy some of the issues around autonomy, and in particular, of course, to enable them to start thinking in terms of how they would dispose of their assets to others on their death. But actually, rather, even more important than that, what they could do for themselves was clearly that's the first priority.
If there were to be an interim payment to the estates of those who have died, those who were infected and died, leaving aside what you said about the difference you saw in terms of the immediacy of need, but if there were to be, presumably it could in terms of the magnitude of it be along the same lines, because the estate claim is unlikely to be less than the figure that you've identified as an interim payment.
I agree with that, but then I'm talking here about, as I repeat, an exceptional measure, and the need of the injured individual, by definition, sadly, no longer exists. And therefore, we're then talking about the reality is the money will be going to elsewhere. It may be going to affected people, but not necessarily when it goes to the estate. There will be all sorts of issues arising as to who should receive the money from an estate. And it would, in my view, be better if all that was sorted out as a complexity in one go rather than several goes.
I anticipate there may be some further questions that people will want me to ask in relation to that, but I will wait and see rather than I'll ask you anything further on recommendation 14 at this stage. Can we go then to recommendation 15, which is page 38, So if we could just look at, thank you, Lawrence. We can go through, I think, some of it pretty quickly, but there are a handful of points I wanted to just explore further. The first point is, in assessing compensation, no account should be taken of any past payments made under the support schemes or their predecessors. And as I understand it, that includes any past payments made from the McFarlane Special Payments No. 2 Trust, which was the amounts paid following the 1990-1991 settlement of the HIV haemophilia litigation.
Yes.
So those are excluded. Sorry, as in no account taken of those either. And then current annual payments under the support scheme should be continued or merged into the compensation scheme and guaranteed for life by legislation or secure government undertaking. And just picking up that point of undertaking, you have suggested that one way of giving that security is a formal undertaking by Her Majesty's government that these will continue for life.
Yes. I received a very strong message that firstly people wanted these payments to continue, but one of the things they worried about was the security and assurance that they would continue, because there was no the difficulty being governments, except by this method, just because one government has said they're going to continue something we might have seen in a number of other fields doesn't mean that the next government is going to do the same thing. That's the feeling of the people I have. So, but for instance, the periodical payments that are made in damages cases are secured by a government undertaking, and whether that requires rules or legislation, I will leave to others. But it is possible for that to happen, and clearly, exceptionally, it should happen here. It doesn't in relation to any form of social security, which, as we know, the rules can change from government to government. This, it seems to me, is a support payment where there should be a guarantee for life, in the same way, in effect, there is for our pensions.
When you say that the payments under the support schemes could be merged into the compensation scheme, does that effectively mean the compensation scheme, the arm's length body, would take over the administration of the existing payments? Yes,
I've been fairly sketchy by design. It was not encouraged, I think, really by the terms of reference to go into the weeds of administration, but it does seem to me that if the support payments are to continue and there's going to be a compensation scheme and there's going to be a relationship between the two, it makes sense for the administration of both to be shared.
We've already, I think, addressed recommendation 15C, the taking into account of payments for the future in terms of assessing future financial loss or care provision. And I don't propose to ask you anything further at this stage about E and F tax. But I do want to ask you a little more about the position in relation to benefits. Could we go to page 116? So at paragraph 9.90, you say, and this is having set out, as we've seen, your recommendation of an uplift in the annual support payments and the tax-free sum for additional financial issues. You say at 990, I recommend that in exchange for the lifetime guarantee of this increased annual sum, uprated annually for inflation, such payments should be taken into account in the assessment of entitlement to any means-tested state benefits. The payments should still be disregarded against any entitlement to non-means-tested benefits, such as disability living allowance. And then if we could turn to page 129. You set out in paragraph 10.10 the current position, which is that a range of means-tested benefits administered by the Department for Work and Pensions discount infected blood scheme payments for the purpose of calculating a beneficiary's income or capital. And then you set out the DWP benefits to which the exemption relates. And then you say that you recommend that the exemption continues to apply to the annual payments that continue to be made under the support schemes or their equivalent under the compensation scheme. Is there a contradiction between paragraphs 990 and 10.10, or have I misunderstood?
I don't think there is a contradiction. What this is about recognising and accepting the continuation of this exemption in terms of the account to be taken of support payments in relation to other state benefit, as I understand it. What I'm talking about in the recommendation is that you looked at is a slightly different issue, which would be subject to this exemption, I think. But where there are other benefits, there is, say for instance, income support, which is independent of anything to do with infected blood, or there are social security issues around that those should be taken into account in the same way. There should be a clawback in relation to that in the same way as there would be in a personal injury claim. So in other words, we don't take account of payments that are being made to do with the infected blood, but there will be people who receive payments that have got nothing to do with this at all. They may have been on support in any event. So that's what I'm seeking to address.
Okay.
And whether I've expressed that sufficiently clearly is for others to judge, but that's what I'm trying to get at.
Again, maybe we need to...
So can I just explain where in a personal injuries claim an award is made of damages, say for loss of earnings, but it is required in every single personal injury case that the Department of Work and Pensions is asked for a certificate as to what has been received by way of defined benefits, and that there is a list of them in the last, I think it's 3 years, it may be 5 years, it's a period, and then that can be reclaimed by the department, and in effect is reclaimed out of the damages. So that's what I'm suggesting, but clearly in this case it would be subject to the exemption that applies to anything that's in these regulations or any similar regulations which exempt those being taken into account for the purposes of those income support and other benefits.
So in terms of any current exemptions, you're not suggesting that should change?
No.
Can I then move to recommendations 16 through to 19? So page 39, please, Lawrence. So I just want to read them out, and then I want to just pick up on, again, a handful of issues relating to them. So recommendation 16, the recommendation of the arm's length body to administer the compensation scheme with guaranteed independence of judgment, accountable directly to Parliament for the expenditure of public funds and fulfilment of its terms of reference.
Yes.
And then you identify 4 aspects of process. Regard to the need of applicants for simplicity of process, accessibility, involvement, proactive support, fairness and efficiency, a review and independent, preferably judicial-led appeal process, so a review process and an appeal process, I think that means.
Yes.
Involve potentially eligible persons and their representatives in the review and improvement of the scheme, for example, by way of an advisory forum, and has access to the records held by or on behalf of any previously publicly funded support scheme. So that's the basis for the scheme. If we then just look at 17, you suggest it should include provision of support services, advice and advocacy service supplemented where necessary by discretionary access to independent legal advice and representation to assist and advise applicants. Just pausing there, where there is a necessity for discretionary access to independent legal advice and representation, that would be funded by the scheme. That's how I've read this, but I just wanted to check.
Oh, sorry, yes. Yes.
And then financial advice and support service to assist recipients in the management of awards and accessing financial services and facilitation of access to appropriate health care and counselling services.
Yes.
May want to come back to that. Recommendation 18, the compensation scheme should be delivered locally within each devolved nation. Consideration should be given by the UK and devolved governments to entering an agreement under which either a partnership board is created to oversee the compensation scheme's ALB, arm's length body, into which the administration of the local support schemes be merged, or the ALB commissions or delegates the local administration of the compensation scheme to the devolved support schemes. Just pausing there, are there 2 features that one draws from this and from the contents of your report? firstly, that the compensation scheme, whatever form it takes, whatever the levels might be, should be a UK-wide scheme. There should be parity between the four nations and none of the disparities that we've previously seen.
And it follows on from the developments really in the support schemes, which has been a move towards, although I don't think it's perfect yet, a move towards parity between the nations. It is to answer your question directly, to be a UK government-funded scheme.
So the same across all parts of the United Kingdom, but it may be administered locally. So there might be, in terms of the way in which that then UK-wide scheme is delivered, and there may be assessors in England, assessors in Wales, assessors in Scotland, assessors in Northern Ireland. So that there's still a degree of local connection and support.
Well, I looked at this really from the applicant's point of view, where it seemed to me absolutely essential that they have a local, the service of this compensation scheme is delivered to them locally, and in many cases, as I've already indicated, personally. And I was very struck by the value that was placed by many people I saw, particularly from Scotland, because there were a lot of people from Scotland, but also from Ireland and Wales, that they appreciated that that local connection and the ability of locally based people, administrators, to understand the context in which people were coming to them. So, I think that therefore is really important. And if we're talking about England, obviously it's a larger place, and one would imagine. One would have to make a decision if you were administering whether you'd have more than the ability to access the service from cities other than London, frankly.
To what extent, if at all, have you considered whether the implementation of the scheme would have to be by legislation?
I suspect that certain aspects of this will require at least some form of regulation. I've deliberately not considered that in detail, and the reason I've not done so, is it seemed to me much more important to work out first what are the needs of a scheme, and then to decide what would be required by way of legislation or regulatory change to bring that about. I mean, obviously schemes demonstrably are brought about without legislation, but many do have it. And of course, legislation is one good way of ensuring that something stays permanent and doesn't disappear with the next government around the corner.
Now, in terms of arm's length bodies, there is more than one kind of arm's length body.
Yes.
And so, I mean, I can think of certainly three types. There may well probably be more. There's a non-ministerial department, an executive agency, and a non-departmental public body. Would it be right to understand that what you're advocating is something which is as independent from and institutionally separate from government as possible?
Yes, I think I'm probably inclined towards the last of those. Just to give some concrete examples, and I suppose it's my own personal experience, a lot of my practicing life was spent in dealing with the General Medical Council. I now sit on the board as a non-executive director of the Care Quality Commission. Those are bodies which are, I might describe as fiercely independent, but funded by the government. In the case of the Care Quality Commission, it is potentially subject to government direction, but not in relation to its operational judgments. So it's that sort of body I would read. And of course, there is undoubtedly an expense and resource implication to the setting up of a body like that, as opposed to having, say, a department within the Department of Work and Pensions. But it does seem to me that the history of this matter, and indeed, however hard we try, the complexity of what is required here does require that sort of organisation, hopefully not overwhelmingly expensive in terms of what it does. But it would have a limited remit. It's not, I mean, there's often a fear about arm's length bodies that they grow like fungus and start taking over more and more things. But this is a very specific thing, and indeed could be possibly one almost might identify a limited life for it. In other words, it's not something that would necessarily go on forever, because sadly, the need for this will at some time stop. And indeed, the time could come, once the assessments are done and everything has been finalised, the actual administration of payments, for instance, might well be, at that stage, be something an arm's length body wouldn't be required to deal with. But at the stage of assessments, determination of awards, the provision of the advice, advocacy, and other forms of support service, that's a complex operation which I think requires an arm's length body.
In relation to some of the history of the schemes, one concern that's been raised in the past, for example, in terms of appointments to the McFarlane Trust, is the extent to which these were appointments of trustees made by the Department of Health. Would it be important to ensure that the appointments that are made to the arm's length body are as independent as possible, potentially with the involvement of Commissioner for Public Appointments or something along those lines?
Yes, I think it's difficult to conceive of a situation where the appointments aren't made by or on behalf of the government, but one can certainly have appointments that are supervised by the Commission, as you mentioned. I mean, in one sense, the judges of this country are appointed via a judicial appointments commission, but the government is involved. But I think there's quite a strong history in this country of independently minded people being appointed to lead, both as non-executives and executives, this sort of operation. So, of course, principles of the Nolan principles and all the rest of it need to be imported into these appointments, and they need to be transparent appointments, and there needs to be, in my view, there would need to be or should be involvement of, as it were, a consumer, the customer interest in it as well, in terms of the board at least.
You recommend in recommendation 16 the involvement of the potentially eligible individuals and their representatives, for example, by way of an advisory forum. Would you support, for example, representation from some of the existing bodies who represent the infected and affected, or at very least their close involvement in the work of the advisory forum?
Well, I don't think I'd would wish to go further than saying that it's important that those who have lived experience of these conditions and those who advise them should be involved and consulted in the design of whatever the service is going to be.
In terms of the appeal process, and you've said it should be independent, preferably judicially led, and I think there may have been some discussion yesterday which picked up on the possibility of the tribunal service performing some function in that regard. One of the issues, again, that's arisen with various incarnations of previous schemes has been the lack of an oral hearing. Would you regard an oral hearing as an important part of the process to ensure the full involvement of the potentially...
We're talking about the appeal?
The appeal.
Well, if it was an appeal, I'm thinking of something either similar to judicial review or something coming through the tribunal service, which, unless I'm wrong, which I could easily be, would automatically involve an oral hearing. The nature of that hearing must depend on what the remit of the appeal was. Not all appeals, some appeals are about the propriety of a process as opposed to looking deeply into the merits. I would see the review as being the stage more where there might be a rehearsal of the evidence, if you like, as opposed to the reasons for the decision, which is what an appeal tends to be about. What I would like to see avoided, if at all possible, is a process of what would seem to the applicants of perpetual litigation before they get to a determination.
Recommendation 19, I didn't refer to, but if we go back, page 40, thank you, Lawrence, you're ahead of me on all of these. I recommend that the proposals for the design and administration of the scheme contained within this report should be reviewed by the government in the light of the findings and recommendations of the inquiry, and thereafter on a periodic basis and reported on to Parliament. If we leave aside the findings and recommendations of the inquiry, because that obviously likely to trigger an obligation on the government to consider what the inquiry reports. What did you have in mind in terms of periodic review and periodic reporting to Parliament?
Well, in part, this is covered by the arm's length body recommendation, because as you will recall, I recommended it should be accountable directly to Parliament, by which I mean rather like the Care Quality Commission or indeed the General Medical Council. A report is sent annually to Parliament, and the accountable officers can and are summoned to give evidence to select committees about their performance, sometimes in quite robust terms. But it is a safeguard against one of the things that I know some people are concerned about, which is, as it were, the biased interference, as they would see it, of the government or departments of the government in the performance of this what would then be an obligation. So I'm really suggesting that, but in addition to the performance, as it were, of the body and the accountability to Parliament, because this is frankly something very novel and also, there's no doubt about it, I'm afraid, expensive in terms of taxpayers' money, but also, as it's novel, as it progresses, there's likely to be learning about how things could be improved, and there should be, as it were, a parliamentary input to that, as well as input from everybody else. And it seems to be that if there's the obligation to report, and I think it would be the arm's length body itself doing that report, there will be a forum within which issues where people were dissatisfied could be aired and improvements made.
Then just picking up on recommendation 17 again, and the reference to support services. If we go to page 139, please. So this is the issue of legal support, and again, this is a matter which I think, for the very reasons you articulate here, is a matter of some importance and concern to those present. So you say, inevitable that the scheme will be complex for many applicants to understand, to prepare their case for compensation and to respond to an offer or assessment of compensation. If, as they did, the Home Affairs Committee considered the Windrush scandal victims required legal support, it's difficult to see how the same conclusion cannot be reached for the victims of the infected blood scandal. And you set out a number of reasons why that might be the case. You outline the kind of advice and assistance at different stages that individuals might need in order to be able to access the compensation scheme fairly. If we go then to paragraph 12.2, the next paragraph, you say it could be provided in one or both of two ways: support staff staffed by lawyers and paralegals, so part of the scheme but independent of those undertaking the assessment. Is that right? Is that what the first bullet point refers
Sorry, could you repeat that?
So that the reference there to a support unit staffed by lawyers and paralegals, you say there that's part of the scheme, but independent of the general scheme administration. So that would be lawyers and paralegals who would be separate from those doing the assessment.
Yes.
So that's one way of doing it. Another way would be independent lawyers.
And I should say the independent, the internal unit, I think, was something that again, going back to the 9/11 schemes they had, although I'm bound to say that was made easier, remarkably, by the fact that no lawyer charged a fee for what they did, which is one of the reasons for the success of the scheme. I have no expectation of lawyers doing the same thing here, and I wouldn't criticise them for not doing it.
And you say in relation to the second bullet point, last sentence, you recommend consideration be given to including all the RLRs, so recognised legal representatives, at the inquiry on the panel, but there may be other firms who can demonstrate appropriate competence or a combination of the two.
Yeah.
And really the point I've been asked by a number of classes, groups of core participants, really, it's more to emphasise than as a question, but picking up on that, it's to say there are many who have built up a long-standing now relationship with their legal representatives who have a knowledge of their own particular circumstances, the history and the background, which would make securing representation by their existing legal representatives something of some importance to them.
I understand that.
And presumably potentially also of practical assistance to the scheme, because you wouldn't have lawyers who are new to this and having to reinvent the wheel.
Well, indeed. There's often, amongst those who have to pay out money, whether it be insurance companies or others, a bit of a distrust about lawyers representing people who are claiming money off them. And sometimes that's justified, but actually, more often than not, the intervention of a lawyer assisting a claimant who's familiar with the background and so on saves everyone time and can save money. And obviously, there need to be safeguards. This is an area, I'm afraid, where to protect individuals from perhaps being exploited by slightly less scrupulous lawyers. And I'm not saying there are many of those, but they do exist. We've seen that in other fields. So, but I think this is an area where actually the scheme itself could well be assisted by someone who is able to formulate a claim and articulate it in the way the scheme understands, whereas the claimant acting on their own might not, and therefore the time taken to process things and the investigations required might be much longer.
That completes what I wanted to ask you about for present purposes, in any event, the recommendations themselves. I've just got a handful of other points that have been suggested to me, which I haven't picked up along the way. One of the features of the scheme that we've discussed and that you've referred to in your report is that for some aspects of the compensation, there might be the tariff payments, but there might be circumstances in which there should be a more bespoke assessment in certain respects. Would that be a choice for the individual, do you think?
Well, I would envisage that being a choice for the individual, but with perhaps a backstop safeguard that there needs to be some grounds for moving to a bespoke assessment. I mean, this scheme is going to be difficult enough as it is, but it's going to be challenged in its ability to deliver what it has to do if every claim has to be bespoke. And if that's the position, then there'd be a heightened risk of this scheme not satisfying its objectives, and you might be inclined then to go to the alternative, which is the Republic of Ireland situation, with all the disadvantages that might have in terms of the time taken to undertake assessment. So I think there would need to be a bit of a conversation about why you might be better off, significantly better off, with a bespoke assessment. And I think that while there may be a choice about raising the issue, I'm not sure I would advocate that it's the claimant's view is completely determinative.
There will be clearly instances in which, whether it's to establish eligibility or to elucidate the claim itself for one aspect or other of the compensation awards, where individuals are going to need to either collate medical information from their records or potentially have, in some instances, medical reports, although, as I understand your recommendation, medical reports are not an integral part of it, of the scheme, and indeed to some extent you're trying to avoid that. But if there is a need in an individual case to get a medical report or to obtain medical records, would it be right to understand your expectation is that the costs of so doing would be borne by the scheme?
Well, in terms of expert reports, well, obviously one with the scheme could not stop applicants getting such reports, and then the scheme would be expected to take those into account. I think I would expect that, in addition, as it were, to the medical panel solution, it seems almost inevitable to me that administratively the scheme would require its own access to ongoing medical advice in some cases. And I would have thought that if we adopt a genuinely collaborative approach about this, that might be sufficient and perhaps a more economical way of dealing with it than a lot of independent experts being instructed by individual claimants. But I think one would have to test that by experience. So I think what that boils down to is that the scheme would have to retain a discretion as to whether or not it was prepared to fund an independent expert on given the merits of an individual case.
If the scheme or the assessor within the scheme were accessing medical advice or medical input, perhaps from their own panel or otherwise, would you agree that would have to be shared with the applicant?
Definitely, yes.
Because again, that's one of the historic concerns.
Any decision, in effect, being made would come with it a need for transparency about the material on which that decision is made.
And then if we just go back to recommendation 16D, page 39. 16D provides for the arm's length body to have access to the records held by or on behalf of any previously publicly funded support scheme. Is it right to understand the rationale for that is so that the individual applicants don't themselves have to gather everything that they've already previously submitted to the support schemes and submitted again?
Yes. It's a short circuit what appears to be currently a rather elaborate process. I mean, there are potential issues of consent, I see that.
Yes.
Here. But those records haven't always been made readily available, and they clearly are, where they exist, potentially very important, because they will show, given my suggestions, eligibility in some cases.
The concern that I've been asked to express, I think that an understandable concern, is that whilst the existing support schemes might well be able to, for example, confirm the status of already eligible people, or they might be able to provide specific relevant information, there is a concern about the entire personal records of the individual held by any existing support scheme simply being handed over to the arm's length body.
Well, I'm afraid I think transparency goes two ways, in that I appreciate these are sensitive personal information, but obviously what the scheme needs is whatever is relevant to the claim for compensation and nothing else. But one can envisage that sensitive information that an applicant would rather not be disclosed would actually be relevant to the determination of the award. And it seems to me that I see no particular justification why that should not be, that the scheme should not have access to that information should a person elect to make a claim.
And then if we go to recommendation 17, paragraph C, that's the recommendation that the support services through the scheme should include facilitation of access to appropriate health care and counselling services. If we could go on to page 137. Because I've been asked to ask you a little more about that, and I just want to look at what's said in paragraph 1132 first of all. So under the heading non-financial support, the scheme should have a support unit which is available to provide or arrange the provision of medical, psychological and social support to infected and affected persons appropriate to the needs caused by the consequences of the infection. The Archer inquiry recommended that the infected should be issued with a card entitling them to benefits not freely available under the NHS, including free prescriptions, counselling, physiotherapy and support services. This recommendation should be revisited and consideration given to whether such a scheme or comparable facility should be provided via the administration of the compensation scheme or otherwise. So just picking up on that latter point first of all, the revisiting of the recommendation of the Archer inquiry, is that something you're suggesting the Department of Health should be doing, or something that's for the arm's length body if set up to consider?
Well, this emanates partly from the Archer inquiry, but also from my understanding that something similar to that actually happens in Ireland. And it's not dealt. I don't think it's a matter that the tribunal service does, but there is a card which gives people, and obviously they have a different system of healthcare,
Yes.
but which entitles people to benefits they wouldn't otherwise readily get to. What I have an impression of, and I by no means have looked at all the evidence that might be relevant to this that the inquiry will have, is that there are certain aspects of the support currently provided, whether it be way of actual care or counselling or support services, which is not coordinated and is difficult for people in some places to identify. I was also impressed by the fact that some of the devolved nations do provide, sometimes a bit in an ad hoc way, support to people about things like financial advice and services and things of that nature. So what I'm seeking to suggest is there is a combination of needs that this particular group has, which is rather different, probably, from that of other people who suffer from other illnesses. And there is a need for an understanding of what it is about these awful infections and the social consequences of them that shouldn't have to be repeated every time to someone in order for them to understand what support these individuals need. So it struck me that there should be an investigation into whether there, in effect, individuals can be issued with a card, which at least will tell the reader of that card who provides the service that these are people who are entitled to it without having to repeat a lot of distressing history. But also there needs to be a facilitation of access to the multiplicity of services that this particular group need, whether that's provided by the Department of Health, NHS England, or the arm's length body, or a combination of those, I think is not for me to say. But all I'm identifying here is a need for signposting, for coordination of services, and for evidencing eligibility for services which isn't being met in some cases in some places. And one route to that could be by way of the compensation scheme organisation. So I emphasise something I think I may have said yesterday, which is, to my mind, compensation here isn't just about money. To put people as near as possible back in the position they would have been without the injury involves, or should involve, the state providing all sorts of care targeted for these people. It may well be care that is available and should be available on the NHS or through Social Security, wherever else, but it's not getting to everyone because of difficulties of access and organisation. And this group, I believe, is large enough for a coordination, as I believe there probably is now in relation to the actual treatment of the diseases.
We don't need to go to it, but you've given some more background to the recommendation in relation to access to health and care services and some of the points that you've just developed on page 135, section 11 of your report. Then, just without going back to the sections of the report or the recommendations that deal with the position of the affected, and we can take that down, thank you, Lawrence. Can I just describe two categories of affected and ask whether what of any consideration has you given to their situation? The inquiry has heard of those placed into foster care after the death of a parent or incapacity of a parent due to infection. How does the scheme reflect that? Is that through the affected person's autonomy or loss of autonomy and social impact awards?
Well, it's also through the Fatal Accidents Act Equivalence Award for dependency, because the loss of a parent and the replacement of that by an inevitably less, not wishing to in any way disrespect lovely foster parents, is an identifiable loss for which I think one would expect to be reflected in a dependency award. So all of that, yes.
And the inquiry has also heard accounts of the position of those who've lost both parents. Again, would you expect that would be something that could or should be captured in some sense through the awards that we've described?
Again, I would see that as being part of the loss of dependency, and it would be the care being provided by grandparents rather than parents would be something classically for which a reflection could be made in an award. So yes.
And then I think the final point that I wanted to pick up arising out of the issues that we've discussed is the position in relation to Scotland. You've been, I think, quite candid that you've focused upon the guidance that can be drawn from the approach to the assessment of damages in England, Wales, Northern Ireland, as opposed to the distinct system in Scotland. There are aspects in which the Scottish system is different. There may be elements of compensation that are more generous, for example, in Scotland. I'm not going to go through specific details or examples, but would it be important, do you think, for the legal panel who would be potentially populating your grids or tariffs with suggested amounts or bands of compensation to include appropriate expertise from Scotland, almost certainly Wales, Northern Ireland, England as well, but reflecting the different nature of the legal system in Scotland to ensure that it's not a lowest common denominator approach necessarily, and that appropriate regard is had to the way in which awards are structured in Scotland?
No, I'd agree that regard should be had to those differences, and it would be obviously helpful for them to be identified. While one wouldn't want to go for the lowest common denominator, you wouldn't necessarily wish to go to the highest common one either. So, and I think one has to come to a fair solution for the entirety of the United Kingdom.
But it's a matter that should at least be considered. It should be part of the assessment process. And then the other point in relation to Scotland in particular...
could I just add to that point? We would have to bear in mind, and the panel would have to bear in mind, that this, and I've said this before, but we're talking about categories of compensation being awarded, which I suspect are no more awardable in Scotland than they are in England. So one has to take into account the rough with the smooth to some extent.
The other point in relation to Scotland, in terms of the Damages Scotland Act 2011, and I think we gave you a couple of extracts. You very kindly did. I'm no more an expert in Scottish law than I think you are, so I'm very grateful to Mr Dawson for that. But the short point, without I think going through the detail of it, is that in Scottish law, a wider category of relatives is recognised for the purposes of bringing what might be the equivalent of claims under the Fatal Accidents Act. Is it fair to say that you had not in your report given any consideration to that?
No.
And so that might be something upon which further reflection might be required by those considering and responding to your report.
At the end of the day, I think there clearly has to be consultation between the governments of the devolved nations and the UK government anyway, and no doubt that would be one matter to take into account.
The last question then just relates to implementation. If we go in your report to I think it's page 122. This is in the context of the discussion about interim payments. But you say in paragraph 9, 130, You say it's unlikely that the scheme could become operational until after the publication of the inquiry report and a process of discussion and consultation, although some elements of the scheme could possibly be set up in advance. Leaving aside interim payments, were there particular elements of the scheme that you thought could or should be set up now?
Well, if, and obviously it's a big if, the principle of a compensation scheme were accepted, if, and again it's a big if, a framework along the lines of that which I've recommended were considered appropriate, you could, for instance, consider setting up in shadow form an arm's length body. You could consider in shadow form setting up the panel, or less than shadow form, probably the panels to start the work of considering some of the detail. Because I absolutely accept that the work of those panels is going to be quite complex. It will require consultation, amongst other things, some research, and I don't see that happening overnight. Frankly, if it'd been able to do that overnight, I might have considered doing it in my own review, but I couldn't. So we do need, and I don't see that sort of exercise needs to await the outcome of this inquiry. But that's so. I completely understand that it might be difficult to go beyond that because, but possibly, and I speculate, would it be possible to, having identified, say, a range of awards potentially for injury, you could start thinking about that. I think when it comes actually to making awards and determinations, though, that is probably the point at which you have to stop. So the ability of a scheme in shadow form to actually distribute money apart from the interim payment, I think, would be questionable. And of course, I have not spoken to and wouldn't intend to speak to the Treasury, but I'd be quite surprised if the Treasury agreed to release money on that rather speculative basis.
But getting the panels to start their work now would mean that if the decision is then taken to press the green light for the scheme, the process of assessing and paying out money would then be would not be delayed as much as it might otherwise be.
And it's there are many instances in which, in advance of a reorganisation, for instance, taking full effect, that bodies are set up in shadow form which will take over that role as and when it's given to them and be designing what they have to design. It's a perfectly normal part of government these days. So I mean, of course, it runs the risk that at the end of the day, a completely different solution is either advocated, which turns out to be a better way of doing it, but so it should be done in a way where the work will not be wasted if at all possible.
So that's where I propose to leave matters. Ahead of 1 o'clock, I'm happy to say, notwithstanding the earlier scepticism about my time estimate.
The scepticism was entirely on your part.
As I indicated earlier, if we could take a lunch break of an hour and a half.
Yes.
Because I think there will be a lot. I know already from speaking to those behind me that there's a lot that they want me to consider.
You don't need to go any further in persuading me. We'll take a break until 2:20. That is no earlier than 2:20. The reasons which have applied before, it may be later, but it will be at least until 2:20. The purpose of this, you probably anticipate, but let me say it anyway. There are a number of core participants, a large number, who are represented by legal representatives. They are entitled to ask counsel to put questions to you. It's part of the collaborative enterprise which this inquiry is. And she must then have a chance to look at those questions and order them and arrange them so that she can then ask them when you return. I can't promise you how long it'll take after 2:20, assuming that we start then. We may start, as I said, later. It depends how many questions are coming through. it'll be however long it takes.
That I understand.
And can I just say, I know there are some here who are unrepresented core participants or unrepresented infected. They should feel free to approach myself and Ms Scott and suggest questions as well.
That's very kind of you.